our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property, Leo, okay? Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, welcome to the show. Today we're talking about the difference in closing a traditional wrap financing and a land contract transaction. If you're new to the show, make sure to like our channel. You can find us on Facebook, YouTube, and X. You can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, you can download an audio version of the podcast. You can find that on Spotify, Apple Podcasts, or any of your other podcast platforms where you can download audio. Go there, download it, leave us a review. It helps us out a lot. We'd really appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So our legal update today is answering the question, what is a buy-sell agreement and when is it used? So basically, I have a lot of investor clients come to me. Many of them have partners that they want to enter into a business relationship with. They want to form an LLC or multiple LLCs, and they basically want to go into business together and be, say, 50-50 partners. And so, we talk about the different scenarios, what happens if, somebody passes away, or what happens if they don't like each other at some point in time, or someone does something wrong, with respect to the business or otherwise, what does that look like? And how do we basically prepare for those situations? And the answer is a buy-sell agreement. So a buy-sell agreement is basically a prenuptial agreement for business owners. It basically says what will happen in a number of different circumstances. So the first is a dissociation of a member, also known as a withdrawal of a member. The legal term is dissociation, but a withdrawal of a member or an owner. The next is a disability of an owner, the death of an owner, the divorce of an owner, or some type of wrongful conduct by one owner against the other owner or the business. It basically has all of those contingencies set forth in the agreement, specifies what it then looks like if the members or the owners either voluntarily or involuntarily want to go a different direction or no longer can, fully participate or work in the business. So it sets things like, the purchase price, how the business is going to be valued, what things are going to be considered in coming up with that membership interest purchase price. It basically allows for the proper separation of business owners. For about 2 years, and this was a number of years ago now, but for about 2 years before I switched my practice to pretty much fully transactional work, I used to do business divorce litigation, and on a fairly large scale with a, decent sized firm in Phoenix. And we would be representing these business owners, and they would be fighting over these, ownership of these businesses that were worth millions of dollars. And these owners hated each other. That's why we called it business divorce. They were separating, and it wasn't, on good terms. And so they would be fighting, and we'd be fighting over the business. And about 90% of those I could look at the situation and what caused the fight, what caused them not to like each other, what caused them to want to go their different ways. And in about 90% of those, had there been a buy-sell agreement, we wouldn't be handling the litigation. There would be no litigation because the agreement would control. But the problem is, in those cases, there was no buy-sell agreement. There was no, set formula for the members to separate. And as a result, they were basically stuck fighting with each other and litigating to figure out what it would look like to, lose for one of them to lose control of the company, because one of them had to lose control. They couldn't continue to operate the company because they couldn't get along. They hated each other or disliked each other significantly. And so, and both of them a lot of times felt wronged, but it was a fight versus a buy-sell would provide in what circumstances, who would take control, who would run the company, how the other person would be bought out. And there would be a formula for all of that. So that is a buy-sell agreement. It's basically your prenuptial agreement for business owners. And when is it to be used? It's to be used if you're going to go into business with another person or individual. You probably want to consider putting that in place.
All right. Thank you, Sean. Sean, as you talk about this legal update, one thing comes to mind. And in my experience, individuals that I've worked with who need an operating agreement are usually kind of short-sighted and oftentimes don't opt to do the buy-sell agreement, whether it's to save money or whether it's they think of the buy-sell like they think of individual estate planning, which is I'll get around to it when I'm 95 years old, right before I die, and that's when I'll do it, kind of thing. What percentage would you say, if you had to guess, actually opt to do the buy-sell agreement when they're doing an operating agreement?
It's between 10 and 20%.
Yeah, that's kind of what I thought you were going to say. And I think, it seems to me one of the things that we say in estate planning is, look, you plan now so you don't have to worry about this later. I would imagine it's probably even cheaper to do the operating agreement and buy-sell together than it would be to try to address a buy-sell years later from scratch, right?
Well, yeah, because the operating agreement that we use for a buy-sell is going to be different than just a standard operating agreement. And so they're paired together. And so if you come back and say, okay, well, I'm ready for a buy-sell, well, you need a new operating agreement as well, because it would take more time for me to amend the agreement to make it compatible with the buy-sell. So yeah, it's cheaper to do it up front than it is, on the back end, because now you're paying for a basic operating agreement and now you need a new operating agreement with the buy-sell. So you're now paying for 3 things instead of 2. And what's interesting is for the clients that I've actually done the buy-sell and who have elected to go that path, there's never really been, with maybe a few exceptions, never really been issues. But it's those that don't put the buy-sell in place that come back a year or 2 later and like, oh, we can't get along. And now we have a problem on our hands. They end up having issues but then they don't have the buy-sell. So what's interesting is, like, when you plan for these things, then generally things work out. But if you don't plan for them, then a lot of times, you end up regretting it.
Yeah. Good information. All right. Few announcements and reminders. Join us today and every day, every Tuesday at 2:00 p.m. Arizona time. We have the Creative Finance Collective. What is that? That is just a space and an opportunity for attorneys that are in the space of creative finance, subject to transactions, to discuss the legal issues that we're seeing from the different states that we approach creative finance from. We have professionals that attend the collective everywhere from Florida to Ohio, California, Arizona, Texas, Alabama, Georgia. We've had professionals from all over the place, but it's an opportunity for us to discuss creative financing. What it also is an opportunity for you to ask questions. So we make ourselves available for the entirety of the hour to kind of discuss creative financing and answer general questions about the process, what it is, the risk rewards. Obviously, it's not meant to take the place of independent legal advice from an attorney in your state, which we often direct people to, but it's a good place to really find out what are some of the issues going on in that space as we discuss it. So make sure to join us every Tuesday at 2:00 p.m. Arizona time, the Creative Finance Collective. And you can watch that and participate on YouTube, Facebook, and X. Make sure to join us. We'd be happy to have you. All right, so we're going to get into our topic today. So today we're talking about traditional wrap financing. Now that might be a new term for some of you, but that's not a new legal term. It's an old one. And we're also talking about that in comparison to land contract transactions, agreements for sale, land installment contracts, contracts for deed. They're called different things in different states. But we wanted to talk about these concepts in their traditional form, what they are and how they are utilized. And with us to discuss that is attorney Jenny Colon. Jenny, thanks so much for being with us.
Hi, thank you so much for having me.
Yeah, we appreciate it. So Jenny, tell us about your law office, what you guys focus on, your location, so on and so forth.
So the name of it's Jenny L. Colon, PC. We get Colin or Colin a lot, but it's Cologne. We're in Chesapeake, Virginia, which is in the Hampton Roads area near Virginia Beach. We practice all over the state of Virginia. So as long as it's in the Virginia walls, we are good to help. So my law firm specializes in investors. So I've been practicing for 17 years, probably done about 50,000 real estate transactions. Most of those now are investor closings. So probably 85% of our regular clientele are people who buy and sell real estate for a profession. So not the regular mom and pop buyers and sellers, though we're happy to take them, but people that are doing just about everything from renovating, wholesaling, doing all sorts of creative financing, building ground up, doing renovation loans. So everywhere in between.
Now, is there any particular focus on residential or commercial, or is it, hey, if you're an investor, we can focus on either?
So we primarily do residential, but we've got lots of commercial clients too. Right now, the boom in Hampton Roads is residential. Commercial is slowing down a little bit, but most of the focus is residential.
I see. I would be remiss, this is slightly off topic, but I was reminded when you mentioned wholesaling. Last week, we spent a good bit of time talking with one of our guests about legislation that's happened, specifically in South Carolina. I know you're not a South Carolina attorney, but what we've seen in Arizona and in other states are more state regulations with regard to wholesaling. And South Carolina passed a wholesaling law. Do you know if Virginia is considering any sort of regulations with regard to wholesaling?
They are. They have updated the definition of what a broker is. It didn't change the code sections very much. And as far as I know, they are not deleting the code sections that allow a person to assign their interest in a contract. We'll have to see what shakes out once litigation starts to happen about that statute. What I think it will probably change is how people are marketing properties, not necessarily whether or not they can actually assign their interest in a contract. So I know you mentioned joint ventures before. A lot of people are under joint ventures and their joint venture partner is who is marketing the property on their behalf. That I think will become a problem if that joint venture partner is not a licensed real estate agent, because they can't market property that they are not actually the buyer of and don't have a license. So I have a feeling that that part of it will change, but practically speaking, people can still assign their interest in a contract to someone else.
Got it. Good information. Well, so today we're talking about traditional wrap financing or wrap transactions, as well as agreements for sale or land installment contracts. What we wanted to do at the beginning of this is just break some of this down. In the age of YouTube and, sexy ways to brand different things, there's this thought that there are these new ideas. Sean spends a good bit of time in the creative financing space, and they love to brand and put like a term to something, and then everybody's like, wow, that's cool. How'd you come up with that? And then they talk about it. We're like, wow, that kind of sounds like a wrap, which we as lawyers have been doing for decades and decades. So let's start here. Give us a definition. What is a traditional wrap transaction?
Traditional wrap is basically a subject to transaction with owner financing. So title is conveyed without paying off the seller's mortgage. So that stays with it. The buyer then purchases the property subject to that seller's existing mortgage. And then at closing, the buyer then executes a note and deed of trust to the seller that wraps in the terms of their contract, which is where wrap comes from. So then the buyer's payments under that note and deed of trust to the seller go to pay that original mortgage. So that kind of situation gives the seller the power to foreclose under that note and deed of trust. So it gives a little bit more protection if sellers are getting a little nervous. That is one way to handle it. Another way is to do a deed of assumption and hold a pocket deed in escrow, which is what we're seeing a lot of. In the event that there's default, then the seller can just get the deed back. So it makes the process of acquiring that property back a little bit easier for that seller. So depending on what sort of seller a buyer is dealing with, they can kind of present different options that make the seller feel more comfortable.
So this is a little outside of, our topic, which was, the wrap and land contracts, which is interesting because in Arizona, we basically have a wrap and a land contract. We don't have deeds of assumption or anything like that. So now I'm curious. So on a deed for assumption, so the property is conveyed by a warranty deed.
Correct.
And then in what document does it say that basically the buyer is assuming the seller's obligations under the loan? Is that like
that is part of the deed. So that's part of the resignations that are in the deed. So it says that the title is conveyed subject to the deed of trust that's recorded at XYZ, and that the buyer is assuming all of the terms of that note and deed of trust.
And then if the buyer doesn't perform, then the property goes back to the seller via a deed that's held in escrow.
Yes.
And what are, because in whether it's a land contract or deed of trust, there's statutory provisions that basically govern that say, well, in Arizona, for example, we have 90 days to foreclose. And anytime during that 90 days, you can fix it. The same with in a land contract in Arizona, which we call agreements for sale, but this is the same thing. In Arizona, under a land contract, there's time periods based upon how much of the principal has been paid, but no less than 30 days notice is given. And then if you fix it in those 30 days, I'm curious, under this deed for assumption and the default provisions, how much time does the buyer have to fix it before escrow then takes that deed and gives it either to the seller or records it?
So that's going to be contractual. Parties can agree to different things. What we typically see is 30 days to default. The seller then has to give written notice to the buyer of their default, and then the buyer has an additional 15 days to cure that default. In the event that that default isn't then cured under that 45-day period, the seller brings that information to the attorney that's holding the pocket deed in escrow, shows that it hasn't been paid, and then that deed gets handed right back over to the seller.
So of the two, wrap versus deed of assumption, which one are you doing more of?
Probably the deeds of assumption. Wrap financing, while it's traditional, it is also becoming a little bit more antiquated because it's double encumbering the property. So sometimes it makes sellers really nervous because their property looks like it's been encumbered 2 times under both different deeds of trust. So what we do see is that people like wraps who the purchase price is more than that assumption balance. What our preference is to do that deed of assumption and then do a note and deed of trust for the difference. So if the purchase price is $200,000, the assumption balance is $150,000, we're then recording an owner finance deed of trust for the $50,000. And then they can either make payments for the full amount or pay just that note and deed of trust to the seller and make the mortgage payments directly. So it really depends on the preference of the parties. We, of course, are happy to help people do whatever they can legally put together. A lot of the times it's what sellers feel more comfortable with. So different sellers, people are funny. So different sellers are going to feel more comfortable about a situation one over the other.
So Jenny, now that we've kind of laid the groundwork for the wrap transaction, Why don't you give us, at least from your perspective in Virginia, explain to us the kind of the definition and difference of a land contract or contract for deed.
So a we call them both here. So either word is interchangeable.
Okay.
So with a wrap financing, it's just like a regular closing. So you have a title examiner who does a search. Somebody is a settlement agent, whether it's an attorney or an escrow company, depending on your state. Title insurance is issued on those. With a land contract, in colloquial terms, it's like a rent to own. So a buyer would take possession of the property, but that deed is not given right away. There's no deed recorded. They're exchanging possession for a contract. So there's a promise to pay. Once that payment is made in full, then the deed is recorded at some future date.
And who holds the deed in that circumstance?
So we have cleaned up a lot of old contracts for deeds where the seller was supposed to be holding the deed and it mysteriously disappears. I never recommend that regular humans hold deeds. It should be held with an escrow company or an attorney. There are precautions in place that if the attorney dies, someone else is taking over their files. That deed doesn't get lost forever. So I never recommend that sellers hold it. Always somebody who is licensed to hold escrowed money or escrowed documents.
Now, on land contracts, what is the purpose? Why? It sounds like the buyer has a lot of rights with respect to the property, or the purchaser has a lot of rights with respect to the properties. But why would the seller retain the deed? Why not just transfer it? What's the purpose there?
Again, it goes to the comfort level of the seller. Some sellers, they don't want to hand over the reins for who's paying their mortgage. They still want to be the one in the driver's seat making those monthly payments. Of course, if a buyer on a subject to defaults, it's affecting the seller's credit score. So a lot of times a land contract is used in the event that the seller wants to retain a little bit more control. We've also seen it in situations where the end buyer is actually going to be an owner occupant, and that person can't qualify for their own loan, and it doesn't look like it's in the foreseeable future, so that they can basically get owner financing at terms that they agree to and continue to make those payments. We've also seen it happen with different VA loans, where VA eligibility could be a question, or whether or not a seller for VA doesn't want to change the title. So it's a lot of personal preference. We've also seen it just because people are afraid of the due on sale clause. So every deed of trust in Virginia has a due on sale clause. It basically says something like, if you change the title, we can call the note. In 50,000 closings, I've seen about 3 notes get called, but holding that deed in escrow under a land contract completely eliminates that risk because no title is ever changing hands.
Now, what happens under a land contract if a purchaser doesn't make their payments to the seller?
Go ahead.
Yeah. How long do you normally have, or what has to happen to basically terminate the contract?
So we have in our contracts that we draft automatic termination provisions in the event of default. That automatic termination is usually 90 days. If you don't have something in there, usually the courts are viewing these as under the Virginia Landlord Tenant Act. So it would fall under regular rental things. Since you would be under a possession agreement, it looks like a rental. So you would end up having to do like an unlawful detainer or some kind of eviction.
Now, if you evict them, though, does that because the land contract's recorded, correct? In Virginia?
We typically record memorandums of contract rather than the entire land contract.
Okay.
We can record the entire land contract, but usually we're doing affidavits of contract or memorandums of contract.
Now, let's say I go and evict the tenant, not the tenant, the purchaser under the land contract, and they're out. I now have possession, but that memorandum is still of record. What do I have to do in Virginia to get rid of it?
It has to be released. So that's why we have automatic termination provisions in the ones that we draft. Again, we've cleaned up a lot of ones that people have brought to us.
Yeah.
In that case, we have to have agreement, or it has to be expired. There has to be some other statutory way to eliminate it, or everyone has to sign a release.
Mm.
So in Arizona, for instance, we have an entire statute, a body of law for agreements for sale that dictate that it's not a foreclosure. They require what they call a forfeiture of the property, and then that equitable interest that's basically being forfeited. There's a process to it. Correct me if I'm wrong, but it sounds like in Virginia, they kind of sounds like they leave that process to contract, or they allow the parties to kind of determine in what sequence they have the ability to terminate the rights under that agreement for sale or land
Yes.
contract.
So if you're doing it an affidavit of contract, then that affidavit has to be released on its own as a separate release document,
Or you need a court order.
or you need a court order.
Oh, wow. Interesting. So what documents are needed to open escrow on a traditional wrap transaction?
Traditional wrap transactions, just like any other purchase and sale transaction, a written contract is required in Virginia. I know some other states have different requirements. We have to have something in writing. And then title search is done. Title insurance is issued typically. There's going to be a HUD-1 statement at closing. Documents are recorded. It looks just like a regular transaction. And then that deed of trust and note are also signed at closing, and that deed of trust recorded after that transaction. So with a land contract, it's a little bit different because you're not doing the same sort of thing. There's not documents that are necessarily recorded, but it also has to start with a written agreement. Most of the time, that written agreement gets signed again after it's finalized at closing, but it's all legal documents with a land contract. It's not other sorts of title things.
Now, in Virginia, is title insurance issued in favor of a purchaser under a land contract?
It is not. So title insurance is
Oh.
not issued on land contracts.
Oh, that's interesting, because in Arizona it's different. That
Interesting.
we actually can open escrow, go through the escrow process, and they will issue title insurance in favor of the purchaser as to their current position on the property, and then that purchaser can basically take that policy when they perform and carry it over to the warranty deed, if you will.
Okay. Yeah. In Virginia, we don't do it like that.
Oh, interesting. Yeah. So for us, well, let's back up. So title insurance isn't issued in Virginia, but do you guys do escrows for land contracts, meaning where the purchaser at least gets the ability to inspect the property and make those determinations and pay their money into escrow, and then that goes to the seller? Do you guys do all that as without
Yes.
title insurance? Okay.
Absolutely. So everything is under whatever their agreement is and what their contract is. So if they get a home inspection, if they want to, there should be some kind of earnest money deposit that's held in escrow. And then all the funds come through the attorney as the escrow agent, but it isn't a traditional real estate transaction because the deed isn't changing hands.
Okay. So the contract that they deliver to your office, say, to start to open escrow for a land contract, is that an actual purchase contract, or do they deliver the actual land contract that has like the inspection period and the closing terms and things like that? What do they deliver to basically begin the process of, finalizing a transaction under a land contract?
We get all sorts of things that people deliver and try to call a land contract. We've seen, half-page documents that try to put together some sort of agreement. We've seen 25-page documents where most of it is crossed out because it was some generic document that doesn't really apply. So we always suggest that our investors have a real estate attorney prepare land contracts. Realtor forms, RAIN forms in Virginia, they aren't set up for that. Generic contracts you can pull off the internet or got at some investor, seminar, they aren't usually set up for that, or they're not state specific. So I always suggest that once an investor has found a party to do a land contract with, that they seek out a qualified attorney to prepare that document for them, because they're so specific to the transaction. using generic forms usually ends up in some kind of trouble.
Yeah, and we see that here in Arizona where people will, do your traditional purchase contract and then say agreement for sale or land contract.
Right.
You're like, well, that doesn't tell me much because there's all these other terms that are unique to a land contract that aren't to, say, a traditional wrap or traditional purchase. So if a client were to come to you and say, okay, Jenny, I am ready to do this land contract and open escrow, prepare a form for me to get started, would you then prepare like a land contract that has all the closing terms and everything associated with that?
So we have fill in the blank forms at my office for people to put the terms on. And then we take that information and draft a unique contract for that particular transaction. We try to get our investors to just use regular language. We have found that a lot of times people are using legal terms incorrectly. So someone will come and ask for a particular thing, but it's not really what that thing is. So typically we ask people to describe what they're trying to do, and then we use the legal words for it. But we have fill in the blank forms for our clients to use so that they get all of the terms, and then we can take those terms and put it into legal terms.
Now, even though title insurance isn't being issued on the land contract, do you still prepare for your escrows like a closing or settlement statement so everyone knows like where all the money's going and all of that?
So it isn't a traditional HUD-1 statement, since
Right.
that is only for an actual real estate transaction, but we do a net sheet. So it's like a balance sheet that shows where all the money goes and who gets it. We also do title searches too. So even though we're not issuing title insurance, we want to make sure that that buyer is under contract to purchase a property that isn't encumbered with a lot of things. So we always do a title search, and we share those title results with the buyer to make sure that everybody knows what they're supposed to be doing.
So now that we're kind of talking about the escrow process and closing, and I know some of this has been might be a little bit of a repeat in what you've said before, but let's just break down from the investor's perspective what documents they should expect to see at close. So with respect to the wrap transaction, what documents are you preparing to have to close this deal?
So traditional wrap financing is going to look like other sorts of purchase transactions. So there'll be a HUD-1 statement. There will be regular sorts of disclosures. You'll see a note and a deed of trust, just as if you were borrowing money from Wells Fargo. So you'll see similar sorts of documents, except that note and deed of trust will be to the seller, not to a commercial bank. So we also have our sellers sign powers of attorney that give that buyer permission to manage the property. If they need to speak with the lender, of course, that loan is going to still be in the seller's name. So we have them sign a power of attorney, giving them permission to talk to that lender in the event that they need to.
What about a deed of release for the deed of trust? We've come across situations where clients have closed on these transactions, and then they decide they're going to refinance, pay off the loan, sell the property, and they've come back and they can't find the seller, or they do find the seller and the seller is uncooperative. And now the seller has a lien against this property, seller's not cooperating. And so what we normally recommend, but sometimes our clients don't follow that advice, is put a loan servicer in place, somebody that you make the payments to, and then they make the payments to the underlying loan. So everything's smooth. And then in that case, you deliver the deed of release and reconveyance to them for the deed of trust, so that you don't even have to mess with the seller. That servicer can give payoffs. They can do everything that needs to be done on a future transaction for the property. In Virginia, do you guys prepare that as part of the closing, and who holds it? When is it prepared?
So we don't call them deeds of release. Here we call them certificates of satisfaction. Same thing. It's what releases the encumbrance off the title, releases that deed of trust. So servicers here can't prepare or can't sign those. It can only be signed by the actual note holder or the trustee of the deed of trust. So if they have evidence that the payments have been made, or the settlement agent under certain circumstances, if they have evidence that all the payments have been made. So Sometimes we try to collect those from the sellers up front, and those cert sats are held in escrow. A lot of sellers don't want to do that, in which case then we do the deed of assumption and we hold the pocket deed in escrow for the seller's benefit. So there is no deed of trust that the seller will have to release at some future time. It's whatever that institutional lender's loan was, which of course they're under all sorts of statutory requirements to release things in a timely manner. So when you do a deed of assumption and a pocket deed, you don't have to worry about where that seller is in 5 or 10 years.
So Jenny, now break down for us the closing documents we'd expect to see in the land contract. How do those differ? And I guess in an extension to that question, a secondary question, which documents are recorded in the two respective transactions?
So on that traditional wrap financing, a warranty deed is actually recorded because title is actually changing hands. And then that deed of trust to the seller is also recorded because you are giving the seller a loan that wraps in the original loan. So on a land contract, the only thing that's recorded is that memorandum of contract, because that deed that would be recorded is then held in escrow instead until all the payments are made. So on a land contract as well, you would see typically the final version of a land contract. So oftentimes what gets signed at the beginning isn't the final version. We usually will make sure that that final version gets signed and is notarized. So oftentimes original contracts are digitally signed or, signed on the hood of a car. We do a final version that's notarized. There's always a possession agreement that looks a lot like a lease, but has terms of that contract for deed embedded in it, allowing that buyer to take possession even though they aren't going to be the owner. We do a power of attorney as well from the seller to the buyer that allows them to manage the property on the owner's behalf. So if they need to change insurance or if they need to make other sorts of modifications or repairs or something, they have permission to do that. There's always an escrow agreement that's also signed that gives the terms of how that attorney is holding that deed in escrow and what those terms are. And then we have them do that affidavit of contract also that gets recorded.
Now, our statutes in Arizona, they kind of have a carrot and a stick when it comes to agreements for sale with regard to that deed that's being held in escrow, so to speak. And our statutes basically say if you're going to have this held by an account servicer or a servicer, not just just holding it in your dresser drawer or something, and an escrow company or a servicer is going to hold this, then we're allowed to. It gives them the benefit of getting that property back much faster. If they fail to do that, they have to do a forfeiture action or a judicial forfeiture action. They have to actually bring a lawsuit. What would happen in Virginia? Somebody comes to you. We did this all on our own, Jenny. Probably shouldn't have, but we lost the deed, but we haven't been paid on this at all. Is there any way of resolving that outside of court?
Not really. So unless there can be some sort of agreement that is made between the two parties, you'd be looking at a court order.
Okay.
So the parties would have to bring all the evidence, just like any other sort of civil suit, show that they had made all the payments and that there was some implied contract if there isn't a deed being held somewhere.
So does Virginia, do they charge or have transfer fees or transfer transactions? And if they do they apply to wrap type transactions?
Virginia's transfer taxes are very high from what I understand. Other people will come and do transactions in Virginia and just be wowed at how high the transfer taxes are. Of course, I only practice here, so I don't have a comparison, but every time a document is recorded, there's recording fees. Every time money exchanges hands, there's transfer taxes that are based on the assessed value or the purchase price, whichever's higher, and the deed of trust or the loan amount. So on a subject to transaction, what most of our jurisdictions will do here locally is they will take that purchase price or assessed value, subtract out the assumption balance, and then base their transfer taxes on the difference. So if the purchase price and assumption balance are the same, part of those taxes are zero. Not all, they do collect some, but part of them is less. So on a land contract, there is no money exchanging hands as far as the court is concerned because documents aren't being recorded. So you'd only have the very nominal recording fee of the memorandum.
So percentage wise of your transactions, are you doing more wraps or more land contracts?
So right now we are seeing way more subject to and wrap transactions because of course over the last 5 years the interest rates have been phenomenal. So a lot of those homeowners have interest rates in the 2s or 3s or 4s, which are very appealing for an investor to come in and take over. So if they do a wrap financing, the seller can charge 6 or 7% to that buyer. All of those fees are wrapped in, and the loan that's being paid off is a much better interest rate than other sorts of transactions. So with land contracts, it depends. So there isn't a set interest rate necessarily because most of those owners own it free and clear. If they do have their own loan that's in place and they're collecting money from the buyer to make those payments, they can set whatever that payment is and adjust it if taxes and insurance go up, just like somebody would if they had a tenant in the property and needed to raise the rent.
So that's the one thing I see here in Arizona, even in Wisconsin where let me back up. In Arizona, I don't think agreements for sale or land contracts are used as much as they should be. Because to me, it seems like a very simple transaction that, like you said, there's greater, it's not perfect because the Fannie Mae Freddie Mac deed of trust would prohibit contracts for deed, but there's less concern about the due on sale. And if they're structured right, there's a lot you can do with them. But people like in Virginia, in Arizona, they want to, do subject to transactions, traditional wrap, financing stuff. I'm also licensed in Wisconsin, and here in Wisconsin, we do a lot of land contracts. In fact, subject to is, and part of it is because we're a mortgage state. And so, it's tougher to foreclose under a mortgage and whatever. So a land contract is generally more amenable to a seller because it can be foreclosed or forfeited quicker. But that's interesting. Do you have the opinion though that maybe land contracts should be used more often than what they are?
We love land contracts.
Yeah.
So the cost is usually less for people over time. If they can get into a good agreement, it can be a real big win-win for both parties. As long as you have an attorney that knows what that is and can structure the transaction and has protocols in place to hold different things in escrow or to advise properly. We really like land contracts here. We have a lot of clients that use them regularly over a wrap financing or traditional sub-twos, and that's their normal go-to. So we advise clients to use land contracts under quite a few different circumstances.
In this environment with high interest rates where you got a lot of investors looking to buy this way because they can get into a loan that's got a much lower interest rate, there's certainly a popularity to it. Are you finding one of the barriers to getting deals done is dealing with attorneys that are in the real estate space, but may not have the experience in kind of this niche area of doing kind of more creative type transactions, right? It's not your garden variety conventional transaction. Are you finding that you're having to do a lot of educating with opposing counsel, so to speak, on the other side of the table?
All the time, every day. Ours is a settlement agent state, escrow state, so attorneys are not required to do transactions. A lot of regular people, even beginning new investors or real estate agents that are trying to get into investing, will just trust their family lawyer or their regular title company. Those companies are just not set up to understand what's going on with creative financing. Becomes very frustrating when we're on the other side. We're literally drawing out the settlement statement, handwriting over things to get people to get the right numbers in place, giving a lot of coaching and education and sending statutes saying what is okay and what isn't okay. We see it a lot. We're trying to educate lots of other title companies and attorneys on a regular basis. It's just not what they do. And that's okay. Everyone has a niche in their own marketplace. But if you're going to get into creative financing, wrap transactions, novation contracts, assignments, wholesales, whatever that creative financing looks like, it is really extra important to find an attorney that is well-versed in those things. The investor shouldn't know more than the attorney about what kind of financing they're trying to do. So if the investor has to coach the attorney or the title company on what they're trying to do, there's a problem. They need to find a new attorney.
What are the common mistakes that you see parties make in their purchase contracts and escrows involving wrap transactions?
We see a lot of templated contracts, a lot of things that people found online or got from some, national seminar on investing. Those templated contracts are not great sometimes. They're not state specific. They have language in there that isn't allowed in Virginia at least, or we see half of the contract marked through, which can cause alarm on the seller's part. They should be drafted by somebody who knows what they're doing. So, or have an attorney create a template for you so that you can use something that works every time. So one of the biggest things that we see on traditional wraps is not having some sort of time frame that the seller can expect for when it's going to be paid off. So we'll often see that wrap, note, and deed of trust have the same due date as the original maturity date on the deed of trust, but there's some sort of conversation between the buyer and the seller about them, refinancing out of it within a year or 2 years or 5 years, but it's never put in writing. So they match and mirror that deed of trust that they're doing for the seller to that original one, which might still have 25 years or 28 years left on it. But there's some sort of expectation that it be done much sooner than that. So that's one of the things we're having to correct a lot when we get these contracts over, is making sure that that time frame is right up front and that everyone agrees to whatever that timeline is. Most sellers don't want to be under a wrap closing and a sub-2 for the next 28 years. They want to be free from it, and they think this is something short term, and the buyer's going into it thinking it's going to be something forever. So we want to make sure that the sellers are on board with all the terms of that. We've had a couple situations where the buyers thought it was communicated and it wasn't, and sellers ended up filing litigation. So Virginia is a very homeowner-friendly state and not a very investor-friendly state. Investors are the big bad guys that should be able to, take care of the little guy. The court is supposed to try to take care of these little homeowners that are getting swindled. So if there is any sort of gray area, the courts are usually finding in favor of the homeowner. And we've seen some transactions get overturned, or at least a lot of pressure put on them because that deadline, that timeline wasn't communicated to the seller. So we always try to make sure that that is right up front and that there's an expectation of when those loans are actually going to be paid off. So we also, of course, see that people who are still under some kind of subject to with a wrap, that can affect their ability to get another loan. It can affect their VA eligibility. So if those sellers don't have a reasonable expectation, can cause a lot of anger and other problems. So we want to make sure they know what's happening. It's also real important for sellers to know who is going to be making their payments. So often we are seeing wrap transactions assigned to another end buyer, which that also causes a lot of problems. Most of the time, subject to transactions are contracted on some sort of trust. That buyer has instilled some sort of trust in this seller that is going to be, basically their financer. And then that buyer assigns it to some unknown entity. That can also cause problems and cause litigation. So even if all the documents are right, that buyer still has to pay to defend themselves. So it becomes this problem. It can damage reputations in the marketplace and all sorts of things. So we want to make sure that in the event that an end buyer is going to be used, that end buyer is actually introduced to the seller and that there is some sort of relationship that's created there too. So we had talked about generic real estate attorneys and generic title companies. So that's another big problem that we're seeing with land contracts and wraps is that, investors or real estate agents are just choosing their regular old guy. That doesn't work sometimes with these different kinds of transactions. They're so specific. They have different ins and outs. They have different requirements, different documents that you would want people to sign. And those title companies or just regular great real estate attorneys, they're just not set up for that. They haven't already done transactions like that. They don't have the right disclosures in place. They don't have the right documents for the seller to sign. They don't even think about having them sign a power of attorney. So it creates future problems if you don't have someone that has done lots of these in the past.
Right.
That's really great information, Jenny. We really appreciate it. Jenny, why don't you tell our audience how they can connect with you, or if they're looking to invest in Virginia and they need an attorney who can do this right and not just rely on Google Forms to do a transaction, how can they get in touch with you?
So our website is the name of the firm. So it's Jenny, Jenny, L, Colon, COLON, PC.com. So all of our contact information is there. The history of our firm is there. How to find us is there. So phone number is 757-277-9803. We have lots of new investors call and ask all sorts of questions. We are happy to get people set up and get a lot of their questions answered to get them on the right track. So whether someone has done one transaction or 100 transactions, we are still here to kind of help coach them through the game. So there's always new things coming up, or someone who's wholesaled everything but now wants to do sub-twos. They have a lot of questions. We're here to help with all of those. So we are happy to take all sorts of phone calls, emails, whatever people have. We're happy to help get those transactions closed.
All right. Well, thank you so much for taking the time to be with us. We appreciate it. Let's do it again sometime.
Absolutely. Would love to be back.
All right. Thank you so much, Jenny. With that, everybody, that is our episode. Make sure to join us for the collective, and we'll see you next week.
Have a good day, everyone.